the 2026 New York City Victims of Gender-Motivated Violence Law, a complete legal guide for survivors. Attorney Andrew M. Stengel. For survivors of sexual assault and gender-based violence in New York City, the legal landscape shifted significantly in January 2026. The passage of Section 10-1104.1, the most recent expansion of the New York City Victims of Gender-Motivated Violence Law, created a powerful new legal tool. The law created an 18-month look-back window allowing survivors to bring civil lawsuits for sexual abuse or assaults that occurred before January 9, 2022. This guide walks through everything survivors and their advocates need to know about the VGMVL, how the new law works, and what steps to take to protect your rights before the window closes on July 29, 2027. What is the New York City Victims of Gender-Motivated Violence Act? The New York City Gender-Motivated Violence Act, formerly known as the Victims of Gender-Motivated Violence Protection Law, is codified in the New York City Administrative Code beginning at Section 10-1101. Originally enacted in 2000 in response to the U.S. Supreme Court's decision in United States v. Morrison, which struck down the Federal Violence Against Women Act's civil remedy provision, the GMVA created a local civil cause of action for survivors of gender-motivated violence. At its core, the VGMVL allows any person injured by a crime of violence motivated by gender to bring a civil lawsuit against the perpetrator, enabling parties and institutions that failed to prevent the abuse. Unlike criminal prosecution, which is brought by the government and punishes the offender, a civil lawsuit is brought by the survivor and seeks financial compensation and accountability directly for the harm suffered. The 2022 amendments and the first look-back window. In January 2022, the New York City Council amended the GMVA to extend the standard statute of limitations to 7 to 9 years, and the law created a temporary 2-year look-back window. The look-back period was open from March 1st, 2023 to March 1st, 2025. During that time, survivors could file claims regardless of when the abuse occurred. The 2022 amendments also clarified that institutional defendants, employers, schools, hospitals, government agencies could be held liable for enabling or failing to prevent gender-motivated violence. This was a critical expansion. That's because individual perpetrators often lack the financial resources to satisfy a civil judgment. Meanwhile, institutional defendants typically carry insurance and have significant assets. The court ruling that threatened hundreds of cases. In 2025, the First Department of the New York Appellate Division issued a ruling in SS versus Rockefeller University Hospital, holding that the 2022 amendments applied prospectively, not retroactively. This meant survivors whose abuse occurred before January 9, 2022, could not rely on the institutional liability provisions or the expanded look-back window. Over 450 lawsuits, many brought by survivors of abuse at New York City juvenile detention facilities, were dismissed or placed in jeopardy. The ruling was a devastating blow to a community of survivors who had finally come forward, only to be turned away by a procedural ruling. Section 10-1104.1, the new 2026 law that changed everything. The New York City Council responded swiftly. Sponsored by Majority Whip Selvina M. Brooks Powers, Introduction 1297-A was passed by the Council on November 25, 2025. Despite a veto by Mayor Eric Adams, the Council voted to override. The new law took effect on January 29, 2026. Section 10-1104.1 does several critical things. Creates a brand new independent civil cause of action for crimes of violence motivated by gender that occurred before January 9, 2022. Explicitly allows claims against parties who commit, direct, enable, participate in, or conspire in gender-motivated violence, capturing both individuals and institutions. Opens an 18-month filing window running from January 29, 2026 through July 29, 2027. Allows survivors who filed qualifying civil claims between March 1, 2023 and March 1, 2025 to amend or refile those claims under the new provision, Who can bring a claim under New York City Administrative Code, Section 10-1104.1? Any survivor who meets the following criteria may have a viable claim under the new law. Location: the abuse occurred within the 5 boroughs of New York City. Timing: the abuse occurred before January 9th, 2022. Nature of harm: the abuse constitutes a crime of violence motivated by gender, a standard courts have consistently applied to all forms of non-consensual sexual contact. Injury: the survivor suffered physical, psychological, emotional, or economic harm as a result. Critically, no police report, criminal charge, or conviction is required. The civil standard of proof, preponderance of the evidence, is significantly lower than the criminal standard of beyond a reasonable doubt. What damages can survivors recover? Under the GMVA, survivors can seek a full range of civil damages, including compensatory damages for medical and psychological treatment costs, lost income, and pain and suffering. Survivors may also recover for the loss of enjoyment of life. In cases involving egregious institutional conduct, such as a school or hospital that knowingly concealed serial abuse, punitive damages may also be available to punish the defendant and deter future misconduct. The July 29th, 2027 deadline: why it cannot be ignored. The 18-month look-back window under Section 10-1104.1 is fixed. When it closes on July 29th, 2027, it closes permanently. There is no indication the New York City Council will open another window. Survivors who have waited this law out, believing their time had passed, must understand. This is the final opportunity to bring these claims. Building a strong civil case, particularly against institutional defendants, takes time. Gathering records, identifying witnesses, issuing preservation letters, and developing a legal strategy all require months of preparation. Survivors who wait until the last months of the window risk compromising the quality of their case. Early action is always better. If you or someone you know was sexually assaulted or abused in New York City before January 9th, 2022, please consult with a qualified sexual assault civil attorney as soon as possible. Contact us now. The New York City Victims of Gender-Motivated Violence Law, and specifically the new section 10-1104.1 provision, represents one of the most significant expansions of survivors' rights in New York City history. It acknowledges the reality of trauma, removes procedural barriers that historically silenced survivors. The law holds both individuals and institutions accountable for gender-based violence. The window is open. The time to act is now. The consultation is free, confidential, and carries no obligation. Schedule a consultation with the law firm of Andrew M. Stengel, PC, by emailing info@stengellaw.com. For more information, please visit our website, stengellaw.com. Attorney advertising. Prior results do not guarantee a similar outcome.